Okay, hi y'all. It's Alabama Law, and we're gonna look at Sheriff Stein's arraignment. The arraignment's easy. I know most of you have never done it. When you first get arrested, you have a preliminary hearing. Usually, you waive the prelim to get your evidence quicker, and then you go to a grand jury. The grand jury can either no bill it or true bill it. If it's true billed, you go to arraignment, and usually Kentucky's a little weird. In Alabama, we had a waiver of arraignment and enter of a plea of not guilty, where you didn't even have to show up. So this normally isn't even done. It's Kentucky. They love wasting time. They just love to waste time being in the courtroom because they don't have anything else. When I practiced there, it was nothing to go 12 hours without even a pee break. I mean, I'm not even joking. So this is how they do it. So we're going to see. My guess is going to come in, waive the reading, and then be done. But let's see what happens. Here we go. Audio is horrible. It's not my fault. It's theirs. They don't have the JAV system on, which is their judicial audio-visual system. You should see red lights. They're probably going to be off. If they were green, that means they're recording. So this is all Law and Crimes feed. See the red light? Right, y'all. All right, come on. Let's speed this up, y'all.
That's correct. And that's Ramsey Valley versus Sean Spence. Mr. Spence is present with counsel.
Yes,
And counsel that is Jeremy Farley.
yes, Your Honor.
Sure, and also the Honorable Jim Cox as well.
All right, how are you? Now, I was up to represent this morning by Mr.
Jackie Stewart.
And your co-counsel in this case
It's Ms. Randy
is
Bell.
assigned to the Attorney General's office.
That is correct.
And that's Ramsey Valley, and she is a trial.
She's a losing green.
We're here this morning for arraignment purposes. All right, counsel, have you had the opportunity to review the argument?
We have, Your Honor. We take a look at the indictment. We got a hard copy of it. And correct.
Do you desire waive any of the,
We'll waive a formal reading and enter not guilty plea at this time, Judge.
and you're satisfied that Mr. Spence is aware of his rights?
Yes,
The
Your Honor.
nature and substance of his work?
Absolutely, Your Honor. Yes.
Like I said, in Alabama, I can't remember if Kentucky has that form or not, but we used to waive the reading, so we didn't even have to waste our time. I mean, this is wasting time to even go to court. The resources on the jail system, having to bring the daggum defendant over in handcuffs, take him back. They're not next door. Usually, the facilities are separate, so it's a waste. But they love the theatrics. Kentucky just loves it. So it gives us something to watch, but this is how it works. After your prelim, which they had the hearing, they found that there was enough probable cause to go forward to grand jury. They went to the grand jury. They indicted him. Now they've waived the reading of it. I tried to look to see if I could find it. I didn't find it offhand, but it's just going to say that they found probable cause for the charge of murder, first degree. And the video is bad. It's bad. I mean, dude's going to try to plead, I'm sure, some sort of we called it EED, extreme emotional disturbance, to try to knock it down into manslaughter. He freaking assassinated the guy. He needs to be working on a plea deal. He'll get smoked by the jury. So anyway, let's see if this is the end of it.
Judge, I'm sorry, I don't mean to interrupt the court. We filed a notice to preserve all evidence, and I have no doubt that Mr. Stewart.
That's to stop spoliation.
We filed that down in district court. I just want to renew that. I will file a written notice as well, Your Honor. And I would just ask the court to go ahead and get our discovery order.
No objection to the question.
So they're already talking about discovery orders. And they're already getting discovery, which they should have already got if they had waived it.
Like you had that, we didn't know when the race was made, the opportunity to get it from her.
Fantastic.
This case was conflicted out, y'all. So I think it was Letcher County, something like that, Southeast Kentucky, and I think they're on the west side of the state.
Yes, Your Honor.
And in this case, I went ahead and set the along after significant consideration, given the implications of Marcy's law.
No bond. Yeah, Marcy's law. We'll cover that in a second. Yeah. Just like I thought.
Judge, and I believe that my understanding was that the court simply doesn't want to pick up bond at this time, but we can still file an adversarial bond.
We have every right to file for that serial bond hearing and that. Anything else?
But if we go from
I will ask that everyone be seated and remain seated until the president testimony comes forward.
Certainly, we can see.
It's my understanding we'll go directly.
And they're doing a bench sidebar, so that's purposely they do that white noise so you can't hear. No, it's over. And that's an arraignment for felony. There you go. Once this is over, we'll talk about Marcy's Law real quick. And that's it. Yeah. All right. So that's it. They're done. Let's talk about Marcy's Law real quick. If I hopefully get it to work. I don't know. It's my second video, so I don't know. We'll see. Oh, old man. Oh, God. Who in the hell is that? Jiminy Crickets, he's old. Well. I'm not sure how to do it. No, it's not right. Present. Share the screen. Ooh, that's not going to work. I may have to just read it off because it's a pain in my butt. Now, hang on a second. Okay. Yeah, there we go. Cool. Yeah, let's try to make this a little larger here. All right. And it's covered up, of course, by this crap. Let me try to go in here and move it a little bit, hopefully. I doubt it. Well, I'm going to let you see that, and I'm just going to read it to you from another page. Key provisions of Marcy's Law in Kentucky. The law was added to the Constitution in November 2020 after being approved by voters and establishes the following rights for victims. 1, notification rights. Victims have the right to be informed of all court proceedings related to the accused. Like I said, unfortunately, before I go any further, my child was brutally victimized in 2021, and it had been going on. We didn't know. My son was the perp. I had him arrested and put in prison because that's where he needed to go. No treatment is fixed. You can't fix somebody with that type of proclivity. It cannot be done, especially at that age. She was under 6. I'm not ashamed of it. She's not ashamed of it. She's a victim. So anybody who wants to sit there and bitch and moan about it, go screw yourself. This has to be talked about. If you don't do it, nothing happens. So unfortunately, Kentucky screwed her over too. They let him go home. He goes back to another state, offends there too, commits another crime, leaves, gets finally yanked on his pretrial, and was finally sentenced last year to, well, he got loose at 18 to go right back to a community and offend again because nobody does anything, because the grand jury wouldn't indict him. 9 Class A, B, and C felonies, and they sent it back. Oh, he might have autism or something. Autistic kids don't get, it's not a defense. It's not a defense. Okay. And unfortunately, they don't care. Everyone wants to be do-gooders. Do-gooders. The best thing they could have done was put him in prison and try him as an adult. They didn't do it. So I'm off the soapbox. I'm just telling you, I know this from experience. What I'm about to tell you is mostly bullshit. Just know that. Okay? It is what it is. The law was added to the Constitution 2020 after being approved by voters and does the following. Notification rights. They don't notify you. Must be changes and notify changes in custody of status of the accused, including release, transfer, escape. Once they're convicted, yes, the state does have an arm of the agency. I think it's under the governor that does contact you. That has been our only good experience, period. Let's see. Must be noticed in case they transfer their custody status, including release, transfer, or escape. They have a right. Victims have a right to be present in all public hearings, even if they're serving a witness. That was a joke. The judge cut us down to like a person, just a person. That's it. Not parents, a person. They're entitled to confer with the prosecutor. That took acts of dang Congress and God to get that even done. And it hadn't have been on my wife, it would have never got done, unfortunately. We were supposed to have input in the plea agreements. We kind of sort of did in sentencing. Victims have a right to be heard at plea, which was a joke. We had to write it down, and it was supposedly put into the record. Whereas in public felony cases like this case, when he's convicted, because he will be, he's on video, they have a right to read their statements. Kind of like y'all may have seen it on the Jeffrey Dahmer documentary they did the series on, where at the very end, he's sitting there and the victims are reading statements, and one black girl, she's reading and she finally says, "I hate you, Jeffrey. I hate you." That's a victim's impact testimony. Let's see. Opinions must be considered before a plea is finalized. Restitution is supposed to get fully restitution. Never happens. They're all broke. They charge $49.95 a night to go to jail here. So in Kentucky, you get $49.95. These people are destitute. They're in jail. They don't have money. So to get out, even on low-level stuff after a year, they have all that back support or back time. Then they have them sign this illegal agreement saying that they'll pay it or get revoked. It's a joke. You can't do that. You can do fines and court costs, but you can't charge jail time. Freaking ridiculous. I will say this, at least here they allow in Kentucky tablets, e-cigs. You go to jail in Alabama, you won't even get sugar for your coffee, if you can call it coffee, because they're afraid you'll make Bruno or prison wine. So, all right. Victims have a right to be heard at plea, sentencing, and other critical stages. Opinions must be considered before it's finalized. Restitution, reasonable protection from the accused during the process. Yeah, right. This includes ensure the victim's safety and privacy. Expedited proceedings. 2.5 years it took us. It was supposed to be done within 45 days because of the age of both. 45 days, 2.5 years. Not exactly fair. Victims have the right to proceedings free from unreasonable delay, ensuring the case moves forward. Dignity and respect, definitely didn't get that. Victims must be treated with fairness, dignity, and respect by all parties involved. Criticisms, and this is almost purely from defense attorneys and public Department of Public Advocacy in Kentucky, which is their state public defender system. Potential conflicts with defendants' rights. Critics argue that expanding victims' rights might interfere with the defendants' rights, such as presumption of innocence. It doesn't, because the jury never hears about it or sees it. Ambiguity. Some provisions are seen as vague, leading to inconsistent application. That's a good argument. And a resource strain. It definitely causes it, but it's the law. That's it. So, it is what it is. All right, so now we've covered that. Let's see if I can get to wrap this up here. Let's see. Okay. Yep. All right. So if y'all like it, please hit subscribe and comment. You can tell me that you disagree with me. I really don't care. It's free speech. Hopefully nothing will get taken down from YouTube or whatever. But next is going to be, I think I'm going to do the YSL closing arguments. And then I've got another one after that I'm going to do. But let me know what y'all want to hear. And if you want to hear how the law really works, I'll even teach class if you want. We could do something on like maybe the rules of evidence. I don't know, whatever you want to do. Just give me drop a like, send or comment, and etc. Okay. Thank y'all. Appreciate it. Bye for now.